Commonwealth versus Chambers uh, addresses a fairly common question, which is how on earth do we go about showing that an agreement existed among parties to a criminal action when we don't have text messages, and we certainly won't have, contractual relationships that they file with the Secretary of State saying, we hereby plan to rob a bank, for instance. Well, in Commonwealth versus Chambers, this one's even harder because if two guys come into a bank, both wearing ski masks, both carrying guns, we can infer that this didn't just happen organically. They at least called a huddle outside the bank and decided we'll both go in there and do this. We don't know when, we don't know how, but those are facts that wouldn't just sort of naturally come together without somebody having decided in advance, here's how it's going to go down. With the fight in Commonwealth versus Chambers, we could imagine this thing occurring without any real discussion. And so we also could imagine, though, that implicitly in this fight, there's an agreement that they'll all keep going, that they'll assist each other. How do you parse that out? How do we know if what's the difference between 5 people deciding to attack a person at once and 5 people agreeing either at the beginning of the fight or midway through the fight that there will be an attack or a continued attack? That's the very difficult question in Commonwealth versus Chambers. And the majority, written by Justice David Wecht here in this case, says we don't have any evidence about any kind of communications that went on that would suggest that anyone asked someone to aid them. They all just started aiding each other. Or in fact, and David Wecht goes even further in this opinion, he says that there's no evidence that Chambers was trying to aid the person who was spraying mace in holding the person back. He was just holding the person, and then the mace just kind of happened. So, and in fact, and there's a real question, if in fact he was anticipating that the mace was going to happen, on what basis was that anticipation made? The dissent here, Justice Dougherty says, wait a minute, look at how it did go down. Sure, we can't infer naturally from the fact they knew each other or some of them were related or the defendant and one of the women who was involved in this were dating. That's not enough by itself to show a common agreement to engage in this fight. But Justice Dougherty in dissent says, look at what happened. In the middle of this melee, Chestnut says he's got a knife, searching for it. That Dougherty's asking for help, or Dougherty says that Chestnut's asking for help in this fight in some way. And that the mace spraying was part of this assistance that was requested in the fight. And it was a fight that was began by Chestnut and his crowd over some silly traffic parking issue. So this case, as I say, raises these really difficult questions of what's enough? What kind of common activity is going to be sufficient to show a common plan or action? This one, I think, is just right there on the line. That you can absolutely see the majority, Justice Wecht, the view that look, we don't see any evidence of communication to suggest a fight. We see evidence that the victim was trying to protect himself and ask for assistance in locating a knife. He didn't say spray him with a pepper spray. He didn't say stab him. He didn't say hit him. But he is fighting this guy while others are helping as well. And the defendant, Chestnut, still has the guy on the ground when the police show up. On the other hand, there is a whole lot of coordination here. A lot of, it's 5 on 1 or 2, depending on what happened to the victim's girlfriend in the midst of all this. And there's definitely communication among these actors. There's, he's got a knife, help me. So Is that enough for an agreement? Is that the mid-fight agreement that Justice Weck says would be enough for an agreement for conspiracy? There's another aspect to this case that's incredibly important, and that is the Pinkerton liability doctrine. There's a U.S. Supreme Court case, Pinkerton versus the United States, that says once two of us agree to engage in a criminal act, everything that follows from that act is something that all the conspirators are now on the hook for. This is kind of like the liability, the natural and probable consequences liability doctrine that we saw in the Tennessee case of Carson in our last class. And as we know in Commonwealth versus Knox, Justice Saylor announced in that opinion that Pennsylvania does not follow that you have to share the same liability as the person who actually commits the crime to be guilty of acts that follow from your assistance. So you help someone rob a bank, and the person gets stabbed, the victim gets stabbed in the midst of this. Are you on the hook for the stabbing if the person doesn't die? Only if you share the degree of mens rea required for the crime that followed. Could you be guilty of third-degree murder? Yeah, absolutely. Or I'm sorry, could you be guilty of aggravated assault? Yes, absolutely. But you have to share the mens rea that's required for that subsequent crime. It's not enough that you join the bank robbery. For Pinkerton, it's enough, much like with Carson in the complicity case. In Pinkerton, it's enough that you join the conspiracy. Everything that follows, you're on the hook for. And Justice Saylor, in his concurrence, says one of the issues in this case that was raised is whether Pennsylvania follows the Pinkerton doctrine. And Saylor says, look, just like we said in Knox, there's a very similar statutory analysis that suggests we don't follow it here. Our Pennsylvania's statutes relating to conspiracy follow, or they track, the model penal code. And much like with complicity, the model penal code commentaries say, we reject the idea of in for a penny, in for a pound. We reject the idea that once you join a criminal enterprise, a criminal conspiracy, or have agreed to commit a crime, once you've agreed to do that, you're not necessarily on the hook for everything that follows. Only if those things that follow, you have the requisite degree of liability, culpability for those subsequent crimes. So Saylor, in his concurrence, says, look, we also, I want to take this chance to say, I don't think that Pennsylvania follows the Pinkerton doctrine that says you're on the hook for everything that follows once you join the conspiracy, much like he had said for complicity with Knox. Remains to be seen what happens with this, but it looks like we're absolutely on track for Pennsylvania to reject the broad Pinkerton doctrine, just like it rejected the broad natural and probable consequences doctrine that the common law had that we saw in the Tennessee and Maine cases from last time.